How you doing? Good. They have score.
All right, good evening. We're going to go ahead and begin our meeting today. We welcome everyone to this Board of Adjustments meeting. Thank you for being here today. We're going to begin, typically, we normally begin with the pledge and the prayer. I've asked Wes to give let's start with the pledge. Andrew will lead us with the pledge, and then Wes will give us a prayer thereafter.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Our dear Heavenly Father, we are so grateful that we are all here to proceed with government and city dealings, and we are grateful for the blessing of order and the blessing of togetherness, and that we can come together as people to solve and figure out problems. And we ask thee, Heavenly Father, that we can be led to know the right path for today's case, and that we will have peace and there won't be discord through it all, and that we can understand and be kind to one another. And we say these things in the name of Jesus Christ. Amen.
Amen. Thank you. For those of you who are not familiar with the Board of Adjustments, let me just run through what we typically do here, or what we'll do here tonight. We'll first read the item into the record. We'll then turn some time over to the Provo City staff for their presentation on the issue, on the item. After Provo City staff is completed, then we'll turn time over to the applicant to provide us her presentation. Following the applicant's presentation, we'll ask if the neighborhood chair is here, if they would like to present any items. Following the neighborhood chair, we'll then open it up to public comment. Given the size, we're thankful everybody's here. We usually don't have this many people here as we do tonight, but we'll probably limit the public comment time to 90 seconds. It's usually what we do. If there's plenty of public comment and we need to go more than that, we can see if we can arrange that. Following the public comment, we may have some follow-up questions for the applicant or for the staff. We'll then close the public portion of the meeting. The board will then debate amongst themselves issues and hopefully come to a conclusion by a motion at that point in time. So without further ado, we'll read item number 1. Jane Loftus requests an appeal of an administrative decision regarding a building permit for a deck located at 326 West, 4620 North in the R2PD zone in the River Bottoms neighborhood. Provo City.
Thank you. So just to give a little bit of additional background and to orient you folks. This is an aerial view of the Georgetown on the Park PD development. This is in northeast or northwest Provo, rather. This is 4200 north, and 4700 north is right up here. Riverwoods is right over there. The subject property that we're talking about tonight is here. This property is owned by Jeff and Cheryl Flake, and they applied for a building permit earlier in this year for a deck that was approved by Provo City staff. The applicant / appellant, Ms. Loftus, her property is right next door. You can see that this is a townhome development with parcels here and then detached garages. These are very beautiful townhomes in this area. This is a view of the zoning for the property, the R2 PD, and just to explain what that means, R2 means two-family residential development. Attached single-family dwellings, like a townhome, are permitted uses in that zone. And the PD overlay is considered what's called a performance development, and it allows for a mixing of different uses on the site, as well as a different configuration of what a traditional subdivision might require. This is a building permit, the approved plans for the deck at the Flakes property. This is an existing view. This is their townhouse here. Looks like they had an existing deck with a staircase into the backyard area. And then this was what was approved. So the deck is here, stairway over there, attached garage coming off of their townhouse. These townhouses are 2 stories plus a daylight basement, and so the main floor of the townhouse matches this top floor of the deck, which is approximately, this is about 5.5 feet or so. These are some pictures that the applicant provided to us as the deck was being constructed. So this is what it looks like at the time that she submitted this application. And then this is a picture of a screening structure that was put up by the Flakes in conjunction with their deck. So I'm just going to go back to the aerial view and then just go through a couple things. The applicant is asserting that the building permit that was approved on July 1st of this year was issued in violation of the code. And so there are actually 2 different issues here at stake that the Board of Adjustments need to consider. The first of which is the appellant's request to appeal timely? And if so, has the appellant shown that the building permit was issued in violation? I just want to go through quickly a couple of the things that were found in your staff reports, and then provide ample time for any questions that you folks might have. In the staff report, I've listed what is the minimum requirements for a traditional R2 zone. The minimum lot area is 6,000 square feet. Lot width is currently at 60 feet. Lot depth is at 90. And then there are minimum front yard and rear yard requirements of 30 feet, and a side yard is 10 feet. And the maximum lot coverage is 40% of the site. So in our code, as it currently stands and as it was established when this project was approved, a performance development is essentially a tool that an applicant can use to construct a project like this, like a townhouse project. And from the code, it says the purpose of the performance development overlay zone is to encourage imaginative and efficient utilization of land, develop a sense of community, ensure compatibility with surrounding neighborhoods and environments. And then in number 2, it says a performance development is a residential development planned as a whole single complex. It incorporates a definite development theme, which includes the elements of usable open spaces, diversity of lot design and residential uses, amenities, a well-planned circulation system, and attractive entrances as part of the design. The incorporation of one or two of these does not make a PD, but the combination of all of these is necessary for the performance development. For this specific project, if we look at this photo right here, I've outlined the perimeter of this project. And the PD zone allows you to view this project as if it was one cohesive development. And so the R2 standards are applied to the project as a whole. So you'll notice these distances here, those equal 30 feet, that's the rear yard, is set back 30 feet from all along here, which is the front required yard area, and as well here. The R2PD allows for individual parcels to be created and recorded for ownership purposes. And those are the blue lines that you see here. So each of these individual lines indicates a parcel that's been created for the purpose of ownership and development on that lot.
So just a clarifying question here. So you're saying these minimum areas apply to the whole complex, not to the individual houses on the space?
That's correct, and I'll illustrate why.
Okay.
So if we come to this one, this is the Flakes property right here. This is approximately 22 feet wide and approximately 88 feet long. That automatically doesn't meet the strict requirements of the zone. If you were to apply the zoning regulations specifically to this parcel, what you would end up is you have to come in 10 feet from each side. So that leaves you 2 feet down the middle, 30 feet from this end, and 30 feet from this end. So that's a total of 60 feet subtracted from 88. So you get a buildable area of 2 by 28. Clearly, that's not possible to build on. And so
And just to clarify, so the area around it actually meets the criteria?
correct.
Okay.
Correct. And that's how it's applied. That's how we have interpreted that. That's in common practice, that's how that's done. I just wanted to go over a few of, the applicant was really helpful in being able to provide some specific questions. The first of which was concerning the timing of this whole situation. And Gary, did you want to have them make a decision on the timing first or proceed on?
Well, so tonight, if the appeal is timely filed, then you have jurisdiction to hear it. If it's not, then you don't have jurisdiction to hear the substantive issue. And so you'll need to decide that tonight. So as a board, one approach is you could have a quick discussion and hear from the applicant about the timeliness of the appeal issue and make a decision there. And if you think it's timely filed, then you move forward with the substantive portion of the appeal. Or you can hear it all together, but at the end, you should make a decision on whether the appeal was timely and go from that
point at the end of hearing all of this discussion. So you really have your choice tonight of which approach you would like to take.
I would encourage, I think we ought to hear the timeliness issue first, and then we can go to the more substantive part of it.
Yeah, I'm no disrespect to the applicant or for all the preparation, but I agree with that point that we should discuss the timeliness first, and then if it is, then we'll go to the other stuff. That's my.
I agree. Let's establish jurisdiction and then go forward.
Okay.
Why don't we, just so we're doing this properly, why doesn't somebody make a motion to that effect?
I'll motion to vote on the timeliness first.
Is there a second?
I'll second that.
All right, all in favor, say yes.
Yes.
So let's talk about the timeliness issue then. Can you address that from a staff report, and then can we have the applicant address that timeliness issue first?
Yeah. So we have Marcus from the city attorney, Marcus Draper from the city attorney's office to address that one.
So what I've handed you is a copy of the prevailing case law on the issue of when the statute of limitations begins to run on this on a Board of Adjustment appeal. And it's a Utah Supreme Court decision from 2008, Fox versus Park City. So I've highlighted a couple of portions that I think are relevant. I want to address the first one. I believe it's on page 10, paragraphs 26 and 27. So a little background information on the kind of underlying facts of Fox versus Park City. This has to do with a building permit issued to construct a full-on building as opposed to a deck, which is what's issued in this case. The neighbors who appealed believe that it violated the height limitations of Park City's code. And so that was kind of the basis for their appealing the issuance of the building permit issued in that case. And so one of the issues came up is whether or not their appeal was timely, much like is the case here. And the Utah Supreme Court determined ultimately that it was not timely. But the irrelevant portion, let's talk a little bit about when the statute of limitations begins to run. Because Park City was arguing that, hey, the code says the second the building permit is issued, their code said 10 days you have to appeal. Our Provo City code says you have 14. But for them to say the 10-day period begins to run the second the building permit is issued. The Foxes said, no, it's not until we have actual knowledge that the building permit has been issued. At that point, that's when the 10 days begins to run. The Supreme Court said you're both wrong. It actually begins when you have actual or constructive notice of the issuance of the building permit. So in paragraphs 26 and 27, the highlighted portion says the appeal period begins when the affected party receives actual or constructive notice that the permit has been issued. Generally, if a party does not receive actual notice of the issuance of the permit, the party receives constructive notice that a building permit has been issued when construction begins. Okay, I had a little bit more than that, but that's really kind of the relevant portion for our purposes. So in the submissions, there's a bunch of email correspondence between at first Javin Weaver and Ms. Loftus. Now, there's an email from July 11th indicating where Javin Weaver tells Ms. Loftus, identifies the specific permit number. The reason it came up is because Ms. Loftus called Mr. Weaver and indicated, hey, they're building this deck here, what's going on? And he says, well, a permit's been issued, here's the permit number, and they started conversing about that. So it's quite clear by July 11th, Ms. Loftus knew they were building a deck. This is important because she claims that it violates, among other things, the lot coverage requirements of the R2 zone. Now, as you can see from that photograph, That covers way more than 40% of the lot, which is what the lot coverage requirement is in an R2 zone. So if you were to interpret the ordinance as she believed it should be interpreted, and I believe still believes it should be interpreted, she was already on notice the second they began construction. Hey, wait a minute, this exceeds 40% already, so obviously any additional construction would violate the lot coverage requirements. So she was already on notice the second they began construction that the issues that she wanted to, at least one of that issue that she wanted to appeal. Also, she argues about the projection into the yard, and again, you can see from the size of the building permit that building permit, it would have been obvious to her at that time that this projected well in excess of anything that she believed was appropriate under the zoning code, and violated all the yard requirements that she raised as an issue in her notice of appeal to the Board of Adjustment in this case. She's aware of all those issues when they began construction, and she replied to that email in the morning of July 12th. So it's quite clear she received the email from July 11th. So the time she was on notice to began construction, she also had actual notice that a permit had been issued, because in the July 11th email, Javin Weaver puts the permit number in the email, says the permit for the deck, PRDK 2019-00995 or something like that. So she was already aware that the permit had been issued. Yes?
Just ask, sorry, not to, so the construction has to begin for it to start? You have
to receive actual or constructive notice of the issuance of the permit.
Okay,
So
actual is...
Actual notice is, I know a permit has been issued, right? Constructive notice is, I'm put on notice, I should know that a permit has been issued by virtue of the fact that they're starting to build.
Okay.
So that's kind of the distinction, and she had both. Javin told her a permit has been issued, as well as they're constructing. So she had both actual and constructive notice by July 11th.
And there's, beyond the actual, there is other proof about them actually starting to construct? They're not, it
Yes,
doesn't matter.
in the email chain, you will note she said they're building this, they're building that. She kept forwarding pictures of the progress of the construction. It's very clear that she knew that they were constructing.
Okay.
But furthermore, she knew that a permit had been issued because Javin told her so. He gave her the permit number. So that triggers the 14 days for the statute of limitations to appeal to the Board of Adjustment. Now, our code says that that's to be strictly construed. You have to follow the procedures, including doing it within 14 days. So following Fox versus Park City, she should have appealed by July 25th. Or if you want to give her the benefit of the doubt, saying she might not have received the email till the 12th, July 26th. Here, the issue is she didn't appeal till July 31st. Now, in her appeal, she submitted some photographs of the progress of construction. And now, we showed these earlier. So,
Are we able to bring those up again?
that one's great. So this is, as of July 31st, you can see the deck is either completed or very close to completion. Now this is very relevant. Now the Supreme Court in Fox explained why it came down to, the decision it did. So I'd direct your attention to page 12, which is paragraphs 35 to 37. Now this is admittedly dicta, but I think it very well establishes the rationale behind the rule that they came down with. We also reject the Fox's proposed rule, which was that you have to wait till they have actual notice, because it conflicts with another well-established rule in Utah, the doctrine of zoning estoppel. This doctrine stops a government entity from exercising its zoning powers to prohibit a proposed land use when a property owner relying reasonably and in good faith on some government act or admission has made a substantial change in position and incurred such extensive obligations or expenses that it would be highly inequitable to deprive the owner of his right to complete his proposed development. To invoke the doctrine of zoning estoppel, the municipality must have committed an act or omission upon which the developer could rely in good faith in making substantial changes in position or incurring extensive expenses. The action upon which the developer claims reliance must be clear, definite, and affirmative nature. A building permit that is applied for and issued in good faith is clearly an affirmative action of the municipality upon which the developer should be able to rely. If a building permit is issued based on a municipality's interpretation of the applicable zoning ordinances, the municipality would be stopped from later asserting a different interpretation and attempting to revoke the permit after the permit holder has incurred extensive expense and reliance on the permit. Using the hypothetical above, the municipality would be most likely stopped from revoking the permit even if the neighbor was allowed to appeal the issuance of the building permit when the building reached a height, which is what was at issue in Fox versus Park City, that alerted the neighbor to the potential height violation. The municipality would be stopped from because the developer reasonably and in good faith incurred extensive expenses in reliance on the building permit, and it would be inequitable to deny the developer the right to finish the construction of the building pursuant to the permit. Here, you can see they were already done by the time Ms. Loftus appealed. There's a very good, sound policy reason for why the Utah Supreme Court came down the way that it did. It's because it's not fair to the Flakes, who relied in good faith on the permit that we issued in our good faith interpretation of our ordinances, and that they were entitled to that permit, to wait till they're done and then appeal. So there's a reason why it's a very tight timeline in which you have to appeal, because they began construction, and Ms. Loftus was aware that she objected to it right away. Called Mr. Weaver, emailed Mr. Weaver, was in communication with Bill Pepperoni, the director of Department of Developmental Services, was in contact with several members of the staff and was clearly objecting to it, but for whatever reason delayed actually filing her appeal till July 31st, which was after the appeal deadline had elapsed and after the deck had already been completed. This is not fair to the Flakes. There's a reason why it's a tight timeline in which you have to appeal. There's a reason why they say when they begin constructing, you're aware that you have an objection to what is going on, you need to get on your appeal. Okay, so she was aware of that.
Can I ask a quick question?
Sure.
Just to make sure I understand this principle correctly, this only, let's say hypothetically the deck were completed within the 14-day period, and it were to be appealed before that deadline, that same expense would still be incurred. But that wouldn't invoke this principle. It would still be...
That's an unsettled question of law. So right there, as I said, and I used, that it was the dicta, and I don't know if you're familiar with that principle, how familiar you are with the principle over dicta.
Please elaborate.
So sometimes in appellate case law, the court will, at every time they'll rule on the issues presented before them, right? Or they'll say some reason why it's not appropriately before them. But sometimes they'll also elaborate on collateral issues that, strictly speaking, the parties haven't raised in the lawsuit. And so that's not considered binding case law in the sense of that was the holding of the case. So here they say, they explicitly say, these issues are not before us, but this is the reason. Essentially, they're explaining their rationale for coming down with the rule that they did come down with on the issue that was before them. But I think it's an important thing to understand that this is not to be unfair to Ms. Loftus. It's trying to balance the interest of Ms. Loftus in appealing it and the interest of the Flakes and being able to rely in good faith on the permit issued by the city. Now, there's a reason why the default is 10 days, and Provo is actually a little bit more generous in giving 14 days to appeal. If they'd done it within 14 days, then we wouldn't be raising the timeliness issue. And if you decided that we were wrong to issue the permit and we revoked the permit, then the Flakes could raise the issue of zoning estoppel in a subsequent case. But that wouldn't be before you right now. The reason I raise that is to explain the policy rationales behind the tight timeline and why it is so critical that you file your appeal timely. So, but the point I'm making is that she was aware that she found the deck objectionable from day one. She should have appealed within timely. She was meeting with Bill Pepperoni on July 22nd within the time frame to appeal. She was in the office. He was shocked when she didn't just go down to the terminal and appeal right then. She waited 9 days after meeting with him to finally file her appeal. It's not fair to the Flakes who had already completed their deck in reliance on the permit issued. It's outside the time, more importantly, it's outside the 14-day timeline. So our position is that she waited too long to raise this issue to the Board of Adjustment.
And can we clarify, if in that 14-day timeline, notice of appeal has to be filed, not necessarily all of your evidence and your full arguments?
That's correct.
Okay.
Thank you. We're going to hear some facts from the applicant, and we've reviewed the file. And so I want you to think about this question, though, Marcus, if you would.
Sure.
Whether that doctrine of zoning estoppel works actually more in their favor than in your favor. Specifically, whether there's a governmental act or omission, or they've made some sort of substantial change that would cause the applicant to be unable to respond or to be able to file. So think about that, and we'll have you come back up after the applicant provides their response here.
Good evening. My name is Craig Carlisle. I'm a lawyer with Ray Quinney Nebeker, and I'll be presenting the appeal for Ms. Loftus today.
Thank you, Mr. Carlisle.
Can I borrow your? So I'll start with the answer to the question. The reason that the appeal was filed on July 31st is because it wasn't before, just a few days before that Ms. Loftus actually had the information necessary from Provo City to determine whether she had a basis for an appeal. And I'm going to go through that with you in some detail and with other citations to the Fox case, and we'll go through that. Because the information was not made available to her until at least, my position is that until the 29th of July, and certainly no sooner than the 17th of July. And so her appeal was timely. So let me just walk through some of that information with you on the with the Fox case. So the case was decided in 2008. It is the governing case. And paragraph 21, I'll just go through some of these quickly, and then I'll point some of the others out to you more specifically. The period starts when the aggrieved party has actual or constructive knowledge of the issuance of the permit. That's already been explained to you. And then generally, the court says, and I think this is at paragraph 21, a party receives constructive notice that a building permit has been issued when construction begins. Now, let me give you a little background on the Fox case. So the neighbor saw they were building 3 residential buildings, and the neighbor saw that they were building these buildings and watched the construction with some interest. I think the neighbor was a builder himself. It wasn't until they got to a point where he thought, hey, this exceeds the height restrictions in Park City. And then at that point, he went into Park City. And the court came back and said, well, that's not, and until you have actual knowledge of the actual height restriction violation, it isn't the test. The test is, once you saw construction, then you would be able to go into, you would assume that there was a building permit. You could go into the city, you could look at what the city had, and you could determine from the plans what the height was going to be. And that's a key distinction in this case, because those plans were never made available to Ms. Loftus, where she could actually make that determination. In paragraph 28, the court said this, quote, if the facts that form the basis of the party's appeal can be ascertained by a review of the application, the party is charged with knowledge of the facts once he or she has actual or constructive knowledge of the permit's issuance. So you have to look at that. That's the important thing, is when you look at the application or whatever's being provided to you, can you make the determination? And she didn't have that information. The court did say significantly.
Sorry, can you direct me to that that paragraph you just read?
Paragraph 23. Let's see if I get to it. Maybe it's 24. All right, let me read this carefully. You start at the paragraph itself. A right to appeal a decision is meaningless, however, if the person possessing the right has no actual or constructive knowledge of the decision. And let's go. Okay, so go down to 28, paragraph 28. It's got the head note there, 37. Thus, a party must not only have notice that a building permit has been issued, but must also have knowledge of the facts that form the basis of the party's objection to the permit before appeal period begins. So, and so we got to look at what's available. Such facts are generally contained in the permit or permit application on file with the municipality. And that's the issue here in our particular case is, yeah, it's on file, but you've got to make that available to her so that she knows and understands what the basis of that decision was, and that didn't happen in this particular case. The court did note also at paragraph 29 that this is a general rule and that there may be exceptional circumstances that may allow a party to bring an appeal even after the appeal period has run. So, and then you go to paragraph 34. Make sure I'm on the right paragraph this time. And it says basically that the rule places, and this is the second sentence down, the rule places on the permit holder the responsibility of providing notice of the permit's issuance, whether it be by beginning construction or by some other means. And once a notice is given, the rule places on the neighboring landowners the responsibility of reviewing the available information to determine if they want to appeal the permit's issuance. That's the key again. What information was made available to Ms. Loftus when she's going through this process? And she was determined. She talked to the office several times, and we're going to go through that a little bit here too, to try to get the information on which this appeal would be, or I'm sorry, the information on which the permit was issued. And I just read to you before where if the information is not provided to her, the information that is necessary to determine whether the building permit was appropriately issued, then her right to appeal is meaningless. And the court decried that at paragraph 25, where you have to have a meaningful right to appeal. So in this particular case, as I indicated earlier, the information was not provided to Ms. Loftus for my review of the facts until 2 days until July 29th. But at best, it would have been on July 18th. So let's go through that a little bit. So and then we'll work backwards. The appeal was filed on July 31st, 2019. So ultimately, the question is, did Provo City make the available information, the information necessary available to Ms. Loftus by July 17th? And as you count days in Utah, you don't count the date of the event, you start the day after, but you include the last day. So in this particular case, the question is, did she get the information before July 17th? So then you go, and what you have, see if I can do this. Well, this is just some introductory stuff, but that right there, I think, is the landing. That was the stairs that they removed to put the deck in. You've seen those. That's another layout of the lots. This is what she saw on July 11th. This is when construction started. They removed the landing here. They removed the stairs going down. That's when she called Provo City and Javin Weaver. She had a discussion with Javin Weaver on July 11th. you've got in your file, you've got this affidavit from Jane Loftus where she confirms that. The second paragraph, or on the first paragraph, she says on Thursday, July 11th, she contacted the city. And then she says she talked to Javin Weaver at, at 4:38 for 12 minutes, and that he told her that a permit had been issued for a deck based on a patio, Provo's definition of a patio. But this is key too. She asked him if he could email plans to her, and he said no because they were copyrighted, so he couldn't send those plans. And that becomes important because throughout this entire process, Provo City is consistent. The plans are copyrighted. We can't show them to you. That's the rest of her affidavit. And then Javin Weaver, this is a declaration that he filed. Subsequently, this process went to the real property ombudsman, and this issue did, and the real property ombudsman ruled in favor of Ms. Loftus that the appeal was timely. Provo City filed this affidavit and one from Bill Pepperoni to try to convince him to reverse his decision, which he did, only in the sense that he said there's a factual dispute, and he'll leave it up to you to decide the factual dispute. In any event, this is what Mr. Weaver said. He doesn't recall Ms. Loftus asking, because she said in her declaration that she had asked for that email. He says he doesn't recall if she did or didn't, or at least it doesn't recall that she asked him to send plans, but it looks like, I mean, some of the subsequent emails that we'll talk about is pretty consistent. The Provo City is always saying copyright, 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 and that's what was confirmed in her email. And then he says here, he said, if she had, I would have instructed her to make a grandma request. And that Ms. Loftus did not make any grandma requests while I was communicating with her. Well, that's true because grandma requests have to be in writing. So then you go to the grandma request statute. And it says, after receiving a request for a record, a governmental entity shall have, A, you can skip because those are emergency situations and this is not one. B, as soon as reasonably possible, but no later than 10 business days after receiving written request. And so that becomes important in Provo because Provo works 4/10s. And so you've got 10 business days in which they have to respond to any request. Well, what does that give you? So you don't count this day, assuming she actually had filed an appeal on the 11th, then you're going to start from the 15th. You got 1, 2, 3, 4, 5, 6. That's a holiday. You don't count that. 7, 8, 9, 10. So Provo City had 10 days to give her information. They effectively wiped out her appeal period with a request for a grandma, telling her she's got to get a grandma request, because they don't have to give her any information until the 31st, which is actually the day she filed her appeal. The statute, and it was just referred to, says that you have to have 10 days. But the other thing in Provo City, they do two things that make it difficult in this regard. They do business days for grandma requests, which is 4/10s, but your appeal period is 14 days. And it's not business days, it's 14 days. And so effectively, by having her go through numerous grandma requests, they were depriving her of her right to appeal because she can't get the underlying information necessary to make that determination. Now,
Did she actually make a grandma request?
she did several of them. She eventually got the documents.
At when date did she do that?
She got the actual plans on the 29th of July.
Well, when did she make the grandma request?
Oh, I think she made the grandma request on the 15th, didn't you? I don't know when the grandma request was, but in any event, I've got them in the file. We gave them, they're with you. There's several grandma requests, but so if you go back to Mr. Weaver's declaration, he said, I responded via email on Monday the 15th of July stating that the deck approval was done according to code. Well, I'm not sure how he reached that conclusion. because on the 22nd of July, Bill Pepperoni writes this email. It says, Jane, there is no copy of R2PD zone in the files pertaining to your development. Therefore, the R2 zone, that is the zoning ordinance, will prevail. That's the first day that she knows that that she can stop looking for a PD overlay to determine what kinds of adjustments had been made to lot coverage, side yard setbacks, and depth from the porch. That's the first day that she knows that we're not looking for an overlay zone anymore. And then in terms of and so now that's why I say so now we got to look. She's still trying to see the plans, and so without the plans, she can't tell what the elevations are and all of those other kinds of setbacks that we'll be talking about a little later. And then Mr. Pepperoni filed this declaration also in an effort to get the ombudsman to change his mind. And he says that up here, he said he met with her on the 18th, Jane Loftus. And at that point, he says that he showed her, we looked at the deck plans from the building permit file on the computer, and I gave her a copy of the plans to Ms. Loftus. Well, if you go back to Ms. Loftus' affidavit, she disagrees that she got the plans right here. And what she got, she did look on the screen about a couple of things that she took photographs of the screen. One was the form of the application itself, but not the underlying supporting documentation. And the other was, and we'll look at it in a minute, basically the site plan. And then he met with her again on the 29th, which I've highlighted there. That's the day that Bill Pepperoni gave her the copies of all of the plans, and that's in her affidavit also. And that's why I say it's a 2-day period. She filed within 2 days of having the underlying information. But even if you went back to the 18th, well, let me show you what she, well, this email is just to highlight that how Provo City was so consistent over this entire period of time that they can't show her the plans because they're copyrighted. This is back in September 25th. She gets a letter from Provo City or an email because she's filed several grandma requests. And they say the combined set plans document has been denied in previous grandma requests due to copyright reasons. However, Bill Pepperoni has previously provided this document to you, so it is attached since it was already previously given. That was the reason they weren't giving her the information that she needed, necessary to make the determination of whether she had a basis for an appeal before this board. And she got it on the 29th. That's what she saw on the screen, is that site plan. You will note that if you look at that picture, that what got built isn't what is shown here. They altered the plan. I don't know if my understanding is they didn't get didn't file an amended permit for that, but that's an issue for another day, I suppose. Where we are at that point is that two things. She didn't know that there was no overlay for this particular project until Bill sent her that email on the 22nd. That's the first time, okay? She didn't know what the underlying facts were, any of the underlying facts, until she got the plans on the 29th. At best, she had this on the 18th. And so her appeal would not, if you went from the 18th, her appeal was filed on August 1st, and it was a day early. And so under all of those reasons, this appeal was timely. I'll just quote from the Fox case again. The facts that form the basis of the party's appeal can be ascertained from a review of the application. She never got the opportunity to do that. And that's why the delay, if you want to call it delay, she didn't delay. But that's why the appeal period didn't start to run until the earliest would be the 18th. You have any questions for me?
I had a few questions. So just to that last statement, do the facts demonstrate that all she received was an email stating what the permit number was? Was there anything in that email that would indicate, that would give her notice that a construction was to begin?
Well, no, because she called She called after she saw that construction on the 11th. That's the first time there was construction had begun, was that the 11th when she called Mr. Weaver. I understand
I thought she was informed, oh, that's when, okay, that was on the 11th, but so there was no email. I thought you said she received an email at some point in time, either prior to that or right around that same time that gave the actual number for the permit.
I think that's the 15th.
That's the 15th email.
Yeah, that's the 15th.
Okay, so I think the argument you're making is that the call on the 11th doesn't constitute actual notice because all she received was a verbal communication as to this is what the permit number is, and she requested information, and I think what you're saying is she couldn't file an appeal because there was no information to review at that point in time.
Yeah, I would go beyond that though, and that is that they refused to, told her it's copyrighted, she can't see it. So it's not just a matter of whether it was available at that point. She couldn't see it. It's all copyrighted. And that's consistent by Provo City and through this whole process.
Can I ask a question to staff here?
Why don't you ask questions for the applicant first, and then we'll have staff come back up.
And I will yield.
So go ahead.
Yeah, I'm just trying to get the timelines right here because there's a lot of emails going back and forth. Okay, so I wrote down a bunch of dates, but I don't know which one. So when did she receive this?
She received that on the 18th.
Okay, and she received notice from the city.
Can I, so when you say receive this, you're referring to the
Site plan.
The
site plan that Ms. Loftus took a picture of.
Thank you.
Okay.
Okay, yeah. So thanks for that clarification. So she received the site plan on the 18th, and then she received notice on the 12th that there was construction, not knowing the plan, but that there was construction going on.
No, I think it's fair to say she knew construction was going on the 11th.
But from the city, there was notice that there was a building permit.
No, on the 12th.
In that email.
On the 11th, on
the 12th.
The 15th, I believe, is when they said there's a permit. The 12th, the city was closed. That was a Friday.
Okay. So timings are all, yeah. So 15th
Critical.
is when Mr. Weaver responded to the
15th.
to the email. Okay.
That's right.
So the 15th is when the city said that there was a permit issued, but she had already known that construction was going on the 11th.
Correct.
And maybe we can hold this for later, but are you saying that this deck plan or any other construction was not sufficient knowledge for her to be able to submit an appeal?
This deck plan, make sure we understand, was shown to her on the 18th.
But regardless, right? So are you saying that the deck plan isn't enough information for her, or it is enough information?
It is not enough information.
It's not enough
For
information.
2 reasons. One, you don't have the dimensions, and it certainly doesn't give you the height issues that we're talking about. The second reason is because she doesn't know that that the P2 or the PD, I'm sorry, the PD overlay doesn't exist, and so it doesn't apply. So until she gets that information, she can't make a determination of whether or not this is violation or not in violation.
Okay. And maybe we'll save this other question, but that picture of the finalized deck was taken on the 31st.
I think that was...
Or earlier. When was that taken?
Remember the final deck? I actually think it was a little earlier than that.
It was earlier. Yeah. Okay. So maybe this is a question for her when she comes to talk, but according to Fox versus Park City, and I want you to talk to this because while Bill responded to an email on the 22nd telling information about that, the deck might have been almost done at that point, and she had clear knowledge of what it looked like beyond what the plan stated. that it could have been beyond the scope of what she interpreted. So I'm just trying to understand when that was taken, because if the deck was kind of finished, it kind of changes its visible construction as well as notice from the city. So she can see clearly how tall it's going to be right from the start, how wide it's going to be right from the start, right? So that's, yeah.
So if we want to, I've got another thumb drive. I can pull up the pictures and I can tell you the date. But the date that the deck, well, I can tell you this. The date that the vertical happened was the 17th of July. So that deck you're talking about didn't go vertical until the 17th. And if you go to the 17th, her appeal is still timely.
So just to clarify that, any kind of, whether it be on paper or whether it be, in physical construction, the substantive elements that were needed to determine whether or not there was case for appeal weren't completed or made available any time before the 17th.
That's correct.
Okay.
That's a summary of it. Now, I wanted to address the one argument that was made here by staff, which is, and I think I've covered this, but they're saying, well, as soon as she saw construction, she could look at the R2 zone and she could tell that coverage had been violated, that the setbacks had been violated, and all those kinds of things, and that anything other than that would be would be a violation itself. No, she didn't know that, because she doesn't know that PD development requirements doesn't exist. And she didn't know that until the 22nd. Until she has that in her hand, together with the plans, she can't make a determination whether she's got a basis for an appeal. Am I clear on that?
Yep.
My last question, and maybe this goes to Bill or staff or someone, but was there communication to her on the timeliness? And had the clock started, and the timeliness that when she's talking to Bill on the 22nd and he says, hey, the clock's already started, why not appeal at that time if you know the timeliness clock is shortened?
So I think if you go to Bill's declaration, he has that conversation with her on the 29th. But he doesn't say when it started. In fact, he says he doesn't know when it starts, because you've got constructive and actual notice. So no, there hadn't been any communication with her saying, hey, your time to appeal has started. And my response to that would be, how can she file the appeal? She doesn't have the information necessary to formulate the basis on which to base an appeal. And so if they're wrong and they say your appeal has started, but she doesn't have the information, that's not, I mean, that's exactly what the Supreme Court said in Fox. You've denied them of a meaningful right to an appeal.
Wouldn't you agree, though, that there's no burden upon the Provo City employees to provide that information?
I agree, and I think Fox says that, which is that once you have notice, actual or constructive, in fact, it does say that, then it's up to the neighboring landowner to then take the steps to try to find out the information. And what the court was saying in Fox is that had they gone to Park City, they would have seen the building plans. They would have been able to determine that the height was going to exceed the ordinance. That wasn't made available to her.
Thank you.
Thank you.
Provo City brief rebuttal.
Can I just ask a procedural issue? Because I think it's our burden to prove, right?
It is.
And as I understood you, I mean, I'm not interrupting, I'll let him respond.
Sure.
That at the end of this hearing, that you may have questions for us, but I was expecting to have some kind of response depending on what comes up in the public
You're
hearing.
certainly welcome to, yeah.
I'd just like to respond to some of the issues raised. One, I mean, Javin emphatically denies that he ever told her anything because she didn't ask. And he's present, and you could hear from him if you would like. But he denies that she ever asked him for the plans and that he denied her access to the plans. Bill Pepperoni indicated that he printed off a copy of the plans and gave it to her on the 18th. So this is got the stamp, it's the approved plans. It is identical to that, notwithstanding what Mr. Carlisle said. The only difference between this and that is the stamp. But he indicates that on the 18th he gave her a copy of the plan. So, because that was the first time she asked for them. Now, there have been issues with whether or not they are copyrighted, but they're moot because she was given the plans. However, she did not ask for them until the 18th, and had she asked for them, they would have been given to her because that's what we did when she asked for them. The evidence is the fact that the second she asked for them on the 18th, we gave them to her. And I think Mr. Carlisle is failing to draw a distinction between the copyright issue. Now, I'm not going to go through the 60 some odd subsections of grandma and what is a protected record. But while we can show copies of copyrighted plans, which was what would have been done had Mr. Pepperoni realized that these were copyrighted, we're not technically supposed to violate that copyright by making copies. But she was offered to be showed them. But since we'd already kind of violated that ship had sailed, we just gave her a copy. But I want to go back.
Hold on one second. So you're saying she was offered to receive the plans, or?
She was given the plans on the 18th, which was the first day she asked for them. And that is according to Mr. Pepperoni. He gave them to her on the 18th.
So prior to that, I think, so Provo City is saying that
She never asked for
never
them.
asked for them, never offered the plans prior to that.
She was not offered them because she did not ask for them.
Okay.
And Mr. Weaver would attest to that. He would come up right now if you ask him to and tell you that. But going back to the July 11th email, I'm just going to read from it. This is from Javin Weaver, Thursday, July 11th, 2019 at 5:52 p.m. Referencing permit PRDK 2019-00995. So the idea that she didn't know until the 15th is not factually correct. She knew on the 11th that a permit had been issued. He specifically referenced the permit number on the 11th. She responded to that, but I want to show, let's see. So show a copy of the July 16th email in the email chain. Hi, Javin, are you sure this complies with city code? See attached pic. As you can see on the 16th, the deck was vertical. It went the full length of the yard. She knew out of all these problems. Now, if you look at Fox versus Park City, the issue is not, do you know the law? The issue is the time starts when you are aware of the facts that form the basis of your appeal. Not that you have ascertained the law, but whether or not you have ascertained the facts. It is quite clear that before July 17th, she had ascertained all the facts she needed for this appeal, and thus the time had run before the 17th, which is ultimately the operative day because she filed on the 31st. So I think that picture is pretty damning to her claim that she didn't know the facts, because you can see that the deck spans the entire length and width of the yard, more or less, just like it shows up in that picture. Now, again, I think there is somewhat of a there's a factual dispute. All right, Javin says, I did not. Now, he phrases in his affidavit, I do not recall, but people often speak in that language. And he is present and available to testify if you would like to hear from him. I think he would tell you, she did not ask me for the plans. And so the defense is based on the idea that the plans were never made available to her, but the facts demonstrate differently. Bill Pepperoni, on the 18th, the first day she asked for the plans, copied them. They showed a picture. They showed that picture that she took a screenshot of on the computer, and he made a copy of the approved plans and gave them to her on the 18th. And that was the first day she asked for it. So Mr. Carlisle has made a lot about the grandma argument. It's regarding some sort of hypothetical set of facts that didn't occur. Had she made it, would we have waited the full 10 days to respond? And if so, would that have deprived her of a right to an appeal? That scenario never occurred, so I don't understand what relevance it has, because it's, sorry, Wes.
Yeah. Is this the email, all of the emails?
No, that is just the relevant portion that I wanted to bring to your attention right now. You have it in your voluminous packet of things. It is something that I wanted to draw to your attention, though, that you can see the picture in the email chain that she sent on the 16th. It was vertical. It was going the full length of the yard. These are all things that she was aware of, all the issues that she raised in her notice of appeal. And now Mr. Carlisle says there's no way she could have known from a legal standpoint until such and such date. But the reality is that's not the burden. The burden is, was she aware of what date was she aware of the facts? That is the triggering date. And the triggering date, in my mind, is the 11th. You could charitably construe it as the 12th because by then you know that she has received Javin's July 11th email, knowing that she's aware of the permit. But you can see on the 16th that as of that date, how far the construction had come along. She was aware of all the facts she needed to know to form the basis of her appeal. For whatever reason, she waited until July 31st. That's, I guess, when she felt she was ready to appeal, but that was too late. And she had waited too long, and that is unfair to the Flakes. They spent thousands of dollars constructing this deck in good faith reliance on a permit issued by the city. And they are allowed to rely on that under the law. And if she waits too long to appeal it, that's unfortunate for her because she objects to it, but it's also not fair to the Flakes if you allow her appeal to be heard because it's untimely. Again, do you have any other questions? I know you wanted to get to the estoppel issue.
I just have a follow-up question, though, but how do you respond to the argument, and you have responded to it to some extent, but I think the appellant or the applicant's argument is that she didn't learn of the PD zone until the 18th, right?
My response would be that that's not the governing legal standard. Now, as the governing legal standard is in Fox versus Park City is when do you become aware of the facts, not the law. Okay, what she's saying is that's when I became aware of the law. Well, that's not the governing legal standard. The issue is when did you become aware of the facts? And the facts were, and that she already found objectionable, is quite clear from looking at the email chain. The facts were that she knew that a permit had been issued July 11th or July 12th, that she was aware that this deck was spanning the whole length of the yard as demonstrated in that photograph on July 16th. So she certainly knew by then, in which case this is still untimely.
Thank you. Any other questions?
I think if we're going to read into the affidavit that says that she did not ask beyond what it states, saying, I don't recall, into an emphatic, it was not the case, I think we would like to hear
Mr. Reed is present. He's more than happy to address any questions you have on
I'd like to invite
what
him
he
up.
meant by that when he signed that affidavit.
Well, are you just proffering his testimony, though?
I'm proffering it now, yeah, but if you'd like to hear directly from the horse's mouth.
His testimony, though, if he's just proffering the same testimony?
Okay.
I mean, do you have questions for him?
No. I just wanted to make sure that we're clear that if we're deviating from what's written in that testimony to make it more emphatic, that we're all agreed that that is the case.
Well, I think what you're saying is there any change in his affidavit that he submitted?
No, I'm saying that what he would say is what he meant by that was that I don't recall it because it didn't occur.
Okay. You're okay? Are you okay?
Okay.
Okay. Thank you. Mr. Carlisle.
I would submit that the memory gets better with time goes on, and you can take that into consideration. I'll just quickly address the picture you're looking at that they just handed to you. Tell me if that's the roof of a pergola or the floor of a deck. I don't think you can tell. So in any event, going on from that, we've got, it makes no sense. If you're reading the Fox case, and the Fox says you have to have a meaningful right to an appeal, and therefore you have to have the basis on which to be able to determine if you've got an appeal, how can you exclude the law from that? Just because I have facts doesn't mean I've got a basis for an appeal. It has to be in some context, and that context has to be the zoning ordinances, so that she can take those facts and compare them to the zoning ordinance and determine whether she's got a basis for an appeal. And until she is told on the 22nd that, no, this doesn't have a PD overlay document, which will say that, whether the setbacks have been eliminated or the lot coverage or any other issues we're raising with you. She can't make an appeal without the law. And to suggest in Fox that you have the obligation to come forward and just say, hey, these facts I don't know if they fit anywhere, but I've got an appeal. That's not even what the form that Provo City has. Provo City has you wants you to identify different provisions in the code on which you're basing your appeal. So I leave that for what it is, because you can't have an appeal if you don't want if you can't put it in facts mean nothing if you can't put it into context.
Thank you.
Thank you.
Any questions for Mr. Carlo? Okay. Procedural question. Do we need to open this to the neighborhood chair and the public for comment on the timing issue alone?
On the timing issue, it's a jurisdictional issue, and I don't think you do, but you could open it up. I think you have that option to do so, and they can address it. Certainly, Ms. Loftus, as the applicant, if she has some things, she should be able to come forward and talk. But as part of a hearing for this is really a question of law and not a factual inquiry.
Well, that's another question, another procedural question. Are we taking a preponderance of the evidence on this issue?
On this issue, I think you're have to, by a preponderance of the evidence, find that to say you did that she does not have, this applicant does not have standing to sue because of the untimeliness of the application, that you have to find by a preponderance that the application was late.
Okay.
And it's a matter of law. You're looking at it as a correctness basis, not that staff was reasonable in their interpretations, but as a matter of law, did staff or is this application correct?
So the drawback here that we have, this is unique. If we look at the preponderance standpoint, we have a Provo City staff member saying, I didn't do something that I never said that. We have the applicant saying, I did say that. I'm presuming if we open it up for public comment, we will get more comments saying, yes, she did. She tried to go and do that. So, which would create additional evidence to be able to rise to that preponderance standpoint.
And again, if the board chooses, you could open it up and ask people to address this very narrow issue.
So let's just have a discussion amongst the board. Any thoughts? You better you gotta turn your mic on. No, I don't have any really thoughts other than.
Well, I think to the extent that that becomes a key sticking point, I would be in agreement to allow comment.
Okay.
I'm kind of, I don't know that it's necessary, but I think that if the applicant wants to speak, I think that's probably in order.
Can I just ask is the neighborhood chair here?
In the back.
Does the neighborhood chair want to address this issue?
The timeliness?
The timeliness issue?
Or no?
But please come to the microphone. Yeah. This is being recorded and we need to pick up what you're saying.
I'm Dave Rosen, the River Bottoms Neighborhood Chair. And with regards to this issue, I do not have exact facts as to the dates that she filed, the dates that she concerned. I can tell you, during the week of the 11th, I was out of town, and I was receiving information from her in terms of emails and things that she was very concerned about what was going on, and she was actively trying to pursue answers that would allow her to proceed with whatever action she could, if they were available to her.
Okay, thank you.
Thank you.
Let me just ask this. Are there other members of the public, by a raise of hand, that have any information or facts that would like to address this specific issue of timeliness? Okay. Let's take public comment, but could we just limit our comments to the brief amount of time as the neighborhood chair just did? If you'll come up and state your name and give us your thoughts.
I'm Terry Clayton, and I have a sworn affidavit for this case. I was in England at the time, going through quite a stressful situation myself with my husband's health, and it was almost on a daily basis that Jane was sharing her concerns with me. I was concerned for her, obviously, and couldn't be here to support her. She felt like she needed a witness in every single thing that she spoke with, to the Provo City. She felt like she needed somebody to witness that because she was worried that they were changing their comments and changing. They didn't know what zoning that Georgetown were in. One of the other things that she was really concerned about was she couldn't find out at first what the zoning was. It's like there was no definite, this development is in this zoning. It was some kind of a special, I don't know, relationship with the developer and the city. So that was a worry. And I've forgotten now what the other thing was. I'm trying to remember as I speak what the other concern was. But there were many concerns, but most of them were that she was getting different answers from different people at the city, couldn't pinpoint anybody down. That's why she was asking to have things put in emails so that she'd have some kind of a paper trail. And one of the frustrating things was that she didn't get to see the plans, even though she believed that they were public record, because she was being told that they were copyrighted. And how can something that's a matter of public record be copyrighted? You know, it was just confusing and it was frustrating for me. And she was very upset and very worried when she saw what was going on.
Yeah, thank you.
Ma'am, would you repeat your name slowly?
Terry Clayton.
Thank you.
Anyone else? Yes.
I'm John Clayton, husband of Terry. Two things really. It seems to me that here we have an ordinary member of the public just trying to get to the bottom of what's going on next door. And no matter how hard she tries, she's being objected to by the city. She just cannot get the information she wants. And then the second thing that springs to mind is, I don't know this for sure, but as I'm driving around, sometimes I'll see a notice saying, this projected building is going to happen. Do you have any objections? And I don't think that happened. I don't think there's ever a notice posted. I might be wrong, but if that had happened, all this process might have been a lot more direct and quicker. We see your notice, we want to object, and I don't think that happened. Thank you.
Thank you.
Thank you.
My name is Kevin Shirtloff. I also have a sworn affidavit that has been submitted. I can tell you that we really didn't know if the deck was in violation until much later. In fact, I was shocked when I went in with Jane, and we talked to Bill Pepperoni, and we said, well, what's the zoning? I mean, is this in violation? We didn't really know until we finally were told that it was R2PD, and we went out on our own. That was the 29th, right? July 20th. We went out on our own and started to research it to see, is there a violation here in terms of this deck? So we really didn't know till much, much later whether it was in violation. We were concerned, but we didn't know there was a violation that could be appealed until much, much later in the process. And I know Jane talked to me on many occasions talking about how they won't show me the plans. They keep telling me it's copyrighted. We can't get access to them. And this is kind of looks like a plan, but it's maybe shows some rough dimensions. It's not what ended, first of all, it didn't end up being that design there, but we have no elevations. And so it was much later in the construction until they started building up that we realized how big and that it was a deck. In fact, at first we thought it was permitted under a patio, but a patio can only be 30 inches off the ground. And it was much later in the construction that we realized this is not a patio, this is a full-size deck. I think the timeliness, She did everything she could in her power to get information from Provo City. And to be honest, when I went in and saw Bill Pepperoni, I felt like we were being strung along. He could not tell us when the date started, how many days we had. We talked to an ombudsman in the city, and they kept saying, oh, we have to go talk to the city lawyer to understand the timing. So we tried to be on top of this. We wanted to get it done before the deck was finished because we realized, Jeff Flake is our neighbor. We didn't want him to incur significant expenses. And so we wanted to get it stopped before it got too far.
Fine. Thank you. Thank you. Anybody else from the public? Yes.
My name is Jane Loftus. I'm the appellant. So I did send an email to Bill Pepperoni on the 22nd of July after we'd met with him on the 18th, and he'd shown us this. He did not give us the plans that day, and we did ask him if these were all the documents pertaining to the permit, because the actual permit said that it was R3 and that they had a 5x8 deck they just wanted to make bigger. There were no dimensions on it. And we asked if this was everything, and he assured us it was. And when we went home, and I asked him, well, what zoning is it? And he said the zoning was lost. And he put that in an email more than once over the next few days. So my husband and I, over that weekend, we became zoning experts, armchair zoning experts, because it's really difficult to do. And so from the best of our knowledge, we just went through each criteria based on whether it was buildable area or not buildable area, and we didn't know. But we knew that we had to, try and figure out if it was in violation. So I sent an email on Sunday the 21st to Bill Pepperoni saying, please stop the work. We believe it's out of zoning. From what we see on the R2 and the PD, we didn't know quite then how to mesh it together. That was done by the former state property ombudsman for us, and that was later. And I sent an email saying, this is not zoning compliant, please stop the work before they put the floor on it and before they put the railings on it. And it was completely ignored. That email was ignored, and then it was later later that day, he said, oh, I just spoke to the city attorney, and he says they're going to stand by the permit. Dave Sewell, and I don't know if he's here, he contacted the city on my behalf, and he said, can you please tell us how this deck, and we were told it was a patio. From day one, we were told it was a patio, and we'd looked that up. So I assumed when I saw the framing going up that was a pergola, just a covering on the patio. I didn't understand it, and the email, if Marcus had shown you the email from the following day, I sent an email to Javin saying, look, the deck is getting bigger, and can I make an appointment to see your boss? Because I can't believe this is within zoning. And so that was on the 22nd that we did that. Subsequent to that, actually on the 19th, I got a text from Jeff Flake saying that he was changing the plan of his deck. So I had no idea, even though I'd seen the site plan, I had no idea of the elevation because I'd been told it was a patio. And then, of course, Jeff Flake, he sent me the text saying we've decided to change the stairs. I asked him why he decided that, and he did not respond to me. So I didn't know what was being built. I tried really hard. But they wouldn't tell me. Thank you.
Thank you.
Thank you.
Anyone else from the public? Yes.
So thanks for hearing this case out, everyone.
State your name.
I'm Jason Loftus. So Jane is actually my mom, and although I don't have an intimate knowledge of all the details of the facts, I looked over some documents yesterday, but it was after work, so I was a little bit tired. But what I can speak to is her character, and more so, growing up, whenever we went roller skating or had to go to school or anything, she's always like, put on all these pads, wear this mouth guard, do everything. You were tardy to one class all semester, you're grounded. So she's not like the most laid back person in the world is kind of what I'm getting at. So I can promise you if she knew on the 11th or the 12th or whenever it was, hey, there's this deck going up and I don't really want that. I feel like it's going to violate code. It's going to be a monstrosity. She would not let it go. There's no way she would be delayed in any manner that was dependent on her and not dependent on someone else. So whether or not, other parties were trying to delay the process to run out the statute of limitations, that's another question. But I can 100% say that it wouldn't be because of hers. So, thank you.
Thank you.
Thank you.
Any other members of the public would like to comment on this small issue? Okay, seeing none, we'll close it for public comment. And we'll have a discussion amongst the board on this timeliness issue. And I'll remind the board, the question is the appellant's or applicant's request to appeal timely?
So, I don't like this law, and I don't like that it makes it very difficult to get information. I don't like that it's a common citizen has to go through a bunch of hoops doing stuff like that. Like, I don't like that personally, emotionally. I do have to say the law, what I interpret is she knew it was in violation probably earlier than when she appealed or when she submitted the appeal. That's my feeling on this. Not even feeling. It looks like, according to Mr. Carlisle, he was talking about it has to be within the context. And when you send a picture of a deck that big, and then on the 15th of July, Javin is saying the approval of the deck was done according to the code. The context is there. It's a deck. It's tall. It's big. It may not even be according to the permit that they did, right? The job of the city is to submit the permit or to approve the permit. And then as soon as somebody files the complaint or the appeal or whatever, then they research that and they do that, right? If you go to the city, and this is just me, but if you go to the city and you say, hey, is this in violation? They're going to say, no, we already approved this. So then it becomes beholden on us as the citizens to make the appeal of what we think is a violation. And from my viewpoint, it's pretty apparent that whether it is violating or not, you felt that it was violating, and you had sufficient amount of time from the 15th or earlier to submit an appeal to that. And that's my understanding of what the law is. I hate it. I don't necessarily agree with the way this is all set up. I think I've talked about it on a different case with the sign on university. I felt the same way. The people didn't have enough information to get there, but the law is that she had the context, she knew how big it was, and it's on her, it's beholden on her to file that appeal in the timely manner. And as much as I don't like it, that's what the law is. And I think to many of the staff, it's go change the law in Provo. And maybe that's a question for Dave Sewell or somebody, right, that's here, or someone along that. But that's my interpretation on it, that it's not a timely appeal.
Thank you, Wes. Andrew, any thoughts?
I I think my thoughts align well with Wes's. I think this is, I can't say how much I believe that local government should be established in such a way that it makes it easy on ordinary citizens to be able to navigate the system, and for there to be someone who clearly cares, clearly has made all these efforts, has invested this time trying to, as in her own words, or to paraphrase, really, became those armchair experts and had to do that work to try to figure out, in what may appear to be just due diligence, just make sure that I have something worth arguing about before I start an argument. I still don't know that we have the latitude to deal with that beyond just saying the time ran out.
Thank you. Yeah. My thoughts on it actually are different than the two of yours. I think that she tried her best to do what she could to form a basis of facts. I accept Mr. Carlisle's argument that there has to be context to put those facts in. And without having that context, you cannot form a basis, you cannot form an opinion. You have, all you have is rawness, and that rawness can't be formed in anything, and I'm not suggesting one party is lying to the other side. I'm not suggesting that at all. I'm only suggesting here that I think they've overcome their burden, at least on this issue, that they've been able to get through and being able to demonstrate that that they didn't have the information in a timely manner in order to be able to present an appeal in a timely manner, other than I think they did submit their appeal, or she submitted her appeal in a timely manner. That's my thought. Now, I know that's against what the two of you are saying, and which...
so I want to just understand, this is why we're discussing, right? So on Monday, July 15th, the context was given that it was a deck. She already had the permit issuance according to the law that there is a construction notice, and then she sends the picture, which in her purview is in violation. So the context is there for her to know there's a violation on the 16th. So at least at that point, there's an opportunity to appeal, right? Or what's the burden on that,
my
right?
thought is that at that time period, I think she's still trying to form an understanding of whether that it's an appealable issue. And that's not the burden. The burden is to say, does she have enough facts to demonstrate that she should appeal the building permit? And I think, at least I'm persuaded, that she couldn't form that opinion because she didn't know it was in the PD zone to even make that opinion. Now, I know I accept Provo City's facts on that issue, and that is they saw it going up and saw it happening, but without understanding, there has to be something around it. Otherwise, we just have raw facts that are meaningless without some context.
Yeah, I think that's well stated. This question of it should be very easy to ascertain what the zoning requirements of your own yard is.
It is actually. You can
Oh, yeah.
request that immediately.
Absolutely. I mean, and I've done it myself for my own yard when I had questions. And I guess that kind of raises the question of where that kind of basic information is. I mean, it just is the case, even if no one could, articulate it. And, maybe someone who really understood zoning could just take a look at how the buildings were built and be like, oh, it must be an overlay, because otherwise this makes no sense. But does the fact that until much later, no one was able to communicate, what your zoning is to provide that last piece of that contextual puzzle. Is that enough to say, is the late date that came through enough to say, okay, yeah, you didn't have enough pieces, so the clock actually needs to start later?
Yeah, it's a good question. At least to me, again, we're just speaking openly here.
Absolutely.
But the argument is, or the facts on the applicant side is, I requested a copy of the plans that's up on the screen currently. I requested this copy. I didn't get a copy. Provo City's saying that never happened, right? So now we have these disputing facts, right, that exist. And at least I'm more persuaded by the testimony of the applicant, only because the applicant doesn't do this for a living, doesn't see this every day, and may have a little more knowledge as to, I tried to get the information in order to form my belief. I tried to get the information. I saw the deck potentially going up, but did I know, this was the testimony is, was it a pergola? Was it a deck? I didn't get that information until the 18th or 19th, whatever the date was. That's where I'm at with it.
Kind of this, I asked for information, but I didn't know the correct set of words that I even had to say, assuming that they didn't ask for it,
That's accurate,
explicitly. They did ask for information generally, and, should it have been volunteered?
Did they ask for, we didn't, I mean, maybe on the phone was asked for, but nobody pulled up any emails saying, can I get the information? We were looking at questions here. Is this, this isn't the whole conversation, right? But it's, hey, is this according to code? Yes, it is. If that was part of the evidence, I think that would have been a headliner. Like, July 11th, can I get the information on this? And I know, I'm trying, I feel for what you guys are feeling. And I think that the law and the timeliness is really difficult. It's a really difficult issue for the Flakes and for you. Right? It's difficult, and I feel that piece of it. But again, it's people try, and it's just a difficult situation, and that's the law. You know what I mean? I don't see. I'm not persuaded by she didn't know. I'm not persuaded by that, especially when you see a picture when it's that big and that tall and that all of that. According to this Fox versus Park City, it's on the visual as well as knowing the city, the building plans and everything. There's a visual component to this Fox versus Park City where you can see clearly how big it is, and if it was going to be bigger, then that's even more reason to call and say, hey, I don't agree with this, I'm going to appeal, right? But you can see clearly how big it is at that point on the 16th, which 14 days later is still not even within the time, even from the 16th. And so that's where I'm I feel for them. I feel for them, but I'm just trying to go with what the law states. And that's where I'm standing. It's very clear the visible statement with Fox versus Park City is just as important in understanding the size and scope of a project, and she could see how big it was already.
Yeah, thank you. Yeah. Any further discussion?
I guess just to Wes, just because I'm trying to kind of settle here, can you maybe, I'd be interested to hear your thoughts on the statement that even at that point in that picture, it was unclear what it was.
Well, the email right before it says the approval of deck was done according to code.
So is that, okay.
There's some context right there that it's a deck, but also I guess she was told earlier, which we don't have that email right here, but it's in the packet probably somewhere,
Yep.
that it was a patio. You can clearly see that it's not a patio within 2 days, 3 days of it being built. So the context within it is still, he's writing patio, deck, it's within code.
I mean, I'm not even sure that, is it within our purview to be determining, if, staff acted appropriately or in a helpful enough manner, or is that something better suited to a court?
Yeah, I mean, my point to all of this, in which I feel like I'm cold-hearted or whatever, but this isn't like how I feel, but this is how I just see it, is that even if the city didn't approve this permit, I mean, they did, right? So even if they approved like a small little patio, it's still beholden on her to make the submission of the appeal to that permit. Like, the city's not going to come around like every 30 minutes or every couple days and say, is it perfect, all these things. If somebody has a complaint about it, they submit it. And they have this time window that unfortunately isn't very easy to know, but most people, if they ask, what's my window, the city would tell them. And I don't know what happened, if she was told that or not. It's still beholden on the citizen to figure that out, which is kind of horrible in my opinion, but that's just the way it is, that it's on the citizen to figure that out and to appeal.
Yeah, and Andrew, I think in response to your question, I don't think we're here today to talk or to judge the staff's conduct, because I think the conduct from everybody was somewhat above board. I don't see anything that says the conduct wasn't above board. I think we're here to look at the facts in their totality, and not to say one party did something wrong or the other party did something right. It's to look at the facts and the totality of it and then make a determination as to whether this appeal was timely filed or not, if that makes sense. So it appears, well, is any other further discussion? Okay, so I'm going to make a motion.
Okay.
I'm going to make a motion that the appellant's request to appeal is timely. And in that motion, I'm going to incorporate that she did not have a knowledge of the facts in order to form a basis of her objection to the building permit, and therefore the appeal was timely filed when made. Is there a second on the motion? We do not have a second on the motion. No. If there's no second on the motion fails. Do we have another motion?
I'd like to motion to uphold the staff's recommendation to say that it is not timely.
Do we have a second on that motion?
I'll second that motion.
All in favor, say...
Before you vote, can I ask a question of clarification on your motion? Yeah. Is your motion that the applicant had actual and/or constructive notice by July 15th or 16th? I think that email that you were referencing with the photo of the deck.
Yeah.
And that by that time, that's when, at the latest date, that you can determine that she had actual and/or constructive notice, and therefore the appeal on July 31st was not timely.
Yes. Do you want me to repeat all that somehow?
Yes, I just want to make sure that I'm understanding, because we're going to have to write a...
Yeah.
Restate your motion.
Yeah, so the motion is that the appeal was not timely based on the evidence and the understanding that there was constructive notice on or before July 15th.
Any discussion on the motion? Okay. Is there a second on the motion?
I'll second it.
All in favor say yes.
Yes.
Any opposed? That's me. With that, that's the end of the day today. I'll remind the applicant, in the report provided, there is a provision to appeal the Board of Adjustment's decision here today. And that can be found in that packet. It's to appeal to the 4th District Court. Do we have any further business? Seeing none, we're adjourned. Thank you.